It's treated informally. The bylaws, the governing documents kind of go out the window. It's more of a friends network that sits on the board. And the issue is they don't really look into how it affects the overall co-op. They kind of just think that because there's 4 units in the building, 3 of them are on the board, they can just pass everything.
The problem becomes when that 4th shareholder moves in who doesn't like what the board's been doing, and then he realizes he has a cause of action against the board because they haven't been acting in accordance with their documents. So for example, if a small building, if they decided to impose a sublet fee or some other kind of fee, and this 4th shareholder doesn't like it, and they didn't do it properly, he can go after them and make them pay back the fees that they've been collecting going back 6 years. So you really want to do it by the book so that no one can challenge it going forward.
Notwithstanding the size of a particular cooperative or a condominium, a board really should be instituting systems, policies, and practices that are tried and true and uniformly applied across the whole shareholder platform. When boards get into an ad hoc basis where they will allow one shareholder to do something and perhaps not allow another shareholder to do so, that is where they get into trouble. One of the great protections that boards of co-ops particularly, and to a lesser extent, but similarly condominium boards have, is the protection of what's known as the business judgment rule, which is more applicable to cooperatives than condominiums. And basically that says that absent some self-dealing or other type of abuse or discrimination, the actions of a board will not be questioned, provided that they acted in good faith. And courts will generally not even challenge the decision. Either the judge would act differently in such a situation. But the importance of instituting a policy before a board acts is what gives them the protection of the business judgment rule, because if they can't point to a particular policy that they have, that opens up the floodgates for a court to potentially then say that they acted arbitrarily and in bad faith.